Hello, I am Douglas Nivens, Staff Attorney in the Baltimore City Office of Maryland Legal Aid. On today's edition of Tenant Thursdays, I will be covering the basics of the Maryland's rent escrow law. The purpose of the law is to help tenants be able to have their landlord cure any type of threats to their life, health, and safety in a rented dwelling with the assistance of the court. In essence, the tenant under court order may pay their rent not to their landlord, but to a escrow account in the court, while the landlord is under order to fix the premises, or allow the tenant to terminate the lease to find a better place to live. There are three prerequisites in order to be covered under the escrow law. First, the tenant must be current in their rent. Second, they must be given notice of some sort to the landlord, preferably in writing, either as a letter by certified mail with a return receipt requested, or even notice by way of a code violation notice from a local health or housing department. But either way, the landlord must have been given an opportunity to know what are the conditions and time to fix them, presumably 30 days. Afterwards, the third prerequisite is that the landlord had an opportunity to cure the threats, but they still remain. If all three prerequisites are fulfilled, then the tenant may succeed. The tenants may go to their district courthouse to file a complaint for rent escrow, which will require a few pieces of critical information. The tenant must provide their contact information, including that of the landlord's, especially a mailing address. The complaint will ask for when notice was given and by what means, as well as a list of the conditions that exist. And lastly, what kind of relief the tenant wants. Does the tenant want to pay rent to escrow, terminate the lease, change the amount of rent paid? All that must be provided in the complaint and filed with the court, whereby a hearing will be scheduled. At the hearing, the tenant, as well as the landlord, will be able to present their cases before a judge who will determine whether the tenant has fulfilled the prerequisites under rent escrow law, that there exists threats to life, health, and safety in the rented home, and that the court decides that it will open an escrow account, and if so, how much money goes in and when. If a court orders the tenant to pay rent into escrow, that escrow may begin that day, at which point the court will determine how much must be paid. The court will also set a schedule for payments, by which means if the tenant fails to make a payment, it may lead to automatic dismissal of the case. However, the landlord will also still be under order to make repairs in the property. Once repairs are complete, either side may move the court to have a hearing, or under some jurisdictions, there may already be a status hearing scheduled. In any event, if the conditions are cured, then the court will have to decide out of all the money paid in the escrow, who gets how much. Now, rent escrow is a legal process in which Maryland Legal Aid provides representation. So you have questions or you want to explore more options related to rent escrow or any other legal concern you may have, feel free to contact Maryland Legal Aid either by visiting a local office or by calling or even completing our online intake process. For more information, you can visit our website at mdlab.org. Take care.